Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So there's been an update in the Rust trial where Alec Baldwin is facing charges for shooting and killing Helena Hutchins. Previously, he had filed a motion to dismiss. He wanted the charges thrown out, and now the prosecution has filed their response. And it's spicy. So let's go through that together.
State's response to the defendant's motion to dismiss the indictment. Now, as you recall, the initial indictment was, or the initial motion to dismiss was kind of spicy. It alleged various improprieties on the part of Ms. Morrissey. And Ms. Morrissey is gonna punch hard when she responds. Now, I'm just going to say, I started highlighting this, and you'll notice that my highlighting is like most of everything, so I gave up on that. All right, so the defendant's motion to dismiss is a predictably false, misleading, and histrionic misrepresentation of the facts and circumstances of the history of the case. Also, they start with comes now. The Fleshlight case doesn't, but this one does. Okay. The two special prosecutors who have been assigned the prosecution of Mr. Baldwin have experienced near countless lies and manipulation from the defense for more than 1 year. In addition, we have, and certainly will continue to be, the subject of the defendant's contrived and unwarranted personal attacks. That's a hell of an intro. And this when I read that, I was like, oh shit, she's got the knives. Like this is going to be a thing. The primary goal of Mr. Baldwin and his counsel, which now numbers 8 total attorneys, Heather LeBlanc, local counsel, who, despite her reputation for hard work and competence, has been relegated to largely menial tasks. Okay. Alex Spiro, New York. Luke Nikas, New York. We're just going to say, they're going to drop some shade about the New York, and that reminded me of this.
Was this stuff made New York City? New York City!
They're going to do a lot of that. So, Texas, Michael Nosenchuk, New York, Jennifer Stern, New York, and Stephanie Kellerman, New York.
Was this stuff made New York City? New York City!
To ensure that the case, so they're basically telling us all of the they're telling us all of these fancy big city lawyers have been brought in, and it's just her against all of these big city lawyers. Just her and her co-counsel there, to ensure that the case is not heard on its merits, and if it is heard on its merits, to discredit the prosecution, investigation, and witnesses in the media, so that conviction becomes unlikely for reasons that have nothing to do with Mr. Baldwin's criminal culpability. It is the job of the special prosecutors to investigate the case and fairly and impartially prosecute the case, and we will continue to do so despite the defendant's relentless attempts to discredit and intimidate the prosecution and the courageous witnesses who continue to participate in the struggle for justice for Helena Hutchins and her family. Damn, she can write. She can write. That is solid writing. This kind of feels like the Braveheart speeches, where she's just laying it out here. Given the exhaustive nature of the defendant's motion to dismiss, we'll begin the response by providing a recitation of the factual and procedural history of the case as we know it. We're going to skip some of this. I'm just going to note, some of you will have noticed that in the bottom corner here, there is a little number that says how much text they're using. It's 316 pages of text. Now, the 316 pages of text is mostly transcripts that they've attached. It's not 316 pages of all of this. And but what that tells us is that not only did she write one banger of a filing, but she also is I'm just going to attach all the receipts. All the receipts are going to be attached to this. So This was Mr. Baldwin's project, and that fact is clear when viewing the many video clips from the filming of the movie and interviewing the crew members. Mr. Baldwin was in charge. Rust Productions hired Hannah Gutierrez, a young and inexperienced armorer, to manage all of the weapons on the gun-heavy movie set, in addition to fulfilling her role as a props assistant. While it can't be denied that Ms. Gutierrez accepted the responsibility for armor and props assistant, so they're saying, yeah, we went after her too because she accepted the responsibility. Ms. Gutierrez was only 24 years old and was only legally permitted to purchase guns for a handful of years. In true Hollywood form, Ms. Gutierrez was hired as the armorer due to nepotism, as her father was a well-known armorer, gun handler, and gun coach. That's Thel Reed. Many of the crew members on the set of Rust immediately noticed that Ms. Gutierrez was inexperienced and overwhelmed, likely with a healthy dose of laziness and bravado mixed in. Curiously, Mr. Baldwin, the most experienced member of all the cast and crew, seems to have missed what most everyone else noticed. Hannah Gutierrez was not up to the job. Alec Baldwin arrived on the set of Rust on October 12, 2021, a week after filming began. Mr. Baldwin's late arrival on set caused him to miss the initial firearms training offered to the actors by Ms. Gutierrez. Baldwin's late arrival made it necessary for Ms. Gutierrez to schedule a separate training session for Mr. Baldwin. Mr. Baldwin was inattentive during this training and spent time during the training on the phone with his family and making videos of himself shooting the gun for his family's enjoyment. See States Exhibit MA and MB. Okay, so I got those videos because they linked them, and we're going to watch them because you're going to maybe have some thoughts about these as we watch these, because this is what Baldwin was apparently doing instead of his firearms training. This is what's being alleged here, is that instead of his firearms training, he was doing this. Now, I got to switch over the audio so that you'll be able to hear it. Hopefully, you guys can hear this. Let me know if you can hear this or not.
Oh, no.
So, that's not great. And there's the second one that was linked. Let's just... what the actual... So I'm going to say it took me a few tries to get this, to find these clips. It took me a few because they don't actually OCR this. I had to like read their crappy writing and find it. When I actually saw what he was doing, it made me lose my goddamn mind. Made me lose my mind because he's playing with the guns. And this is not a film set. This is not like filming. There's people recording this on cell phone cameras. Guns ain't toys. And he's firing this at very close distance to those people who are filming. I mean, he's aiming it away from them, but he's firing it at very close distance. I was just like, oh my God. And this speaks very poorly both of Alec Baldwin, because he was doing this, and also of Hannah Gutierrez, because she should not have allowed this. I can tell you, I am not a film armorer. I've spoken to a lot of very qualified film armorers. I can't imagine any of them would have allowed this. And he's sweet. Like, that gun is loaded with blanks, right? Blanks are dangerous at close distance. He sweeps the gun past the people who are there filming. If he inadvertently touches the trigger as he's doing that, he could have hurt or killed one of those people who was filming. This is supposedly his training session? Holy shit. So, upon arriving on set, Mr. Baldwin immediately began demanding the crew and the armorer work faster. Mr. Baldwin's relentless rushing of the crew on the movie set routinely compromised safety because Rust is not a romantic comedy. It is an action-filled Western with dangerous stunts and real guns being used as props. In addition to rushing the cast and crew, Mr. Baldwin was frequently screaming and cursing at himself, at crew members, or at no one, and not for any particular reason. Translation, the allegation is that Mr. Baldwin is a jerk. To watch Mr. Baldwin's conduct on the set of Rust is to witness a man who has absolutely no control of his own emotions and absolutely no concern for how his conduct affects those around him. It's the wrong use of effects, but okay. Witnesses have testified that it was this exact conduct that contributed to safety compromises on set. The combination of Hannah Gutierrez's negligence and inexperience and Alec Baldwin's complete lack of concern for the safety of those around him would prove deadly for Helena Hutchins, a young cinematographer and rising star in the film industry. Ms. Hutchins was shot and killed by Alec Baldwin, who pointed a .45 caliber single-action Army revolver at her, cocked the hammer of the gun, and pulled the trigger when a scene was not being filmed and cameras were not rolling. The bullet entered her body near her right armpit, went through her rib, punctured her lung, severed her spine, and exited her body below her left shoulder blade. The bullet then entered the front shoulder of director Joel Souza before finally coming to rest just under the skin on Mr. Souza's back. Why is she saying this? Because she's saying this is not a game. This is serious. This killed a woman, and this very seriously hurt Mr. Souza. At the time, a scene was being prepared during which Mr. Baldwin was expected to slowly pull his gun from his holster. That's all. Mr. Baldwin decided to go off script and take actions contrary to what the director, Joel Souza, instructed him to do. To the frustration of Mr. Souza, Mr. Baldwin did this frequently. He ignored direction from Mr. Souza and, without warning, acted on his own volition. So he's a loose cannon. That's a problem. Unbeknownst to Mr. Baldwin, Ms. Gutierrez inadvertently loaded a live round into the gun, and Ms. Hutchins and Mr. Souza were shot. Ms. Hutchins died the same day. Almost immediately after the incident, when emergency medical services were still on scene and attempts to stabilize Ms. Hutchins for flight to the UNMH Trauma Center were underway, Mr. Baldwin began preparing for the unbelievable narrative that he was not responsible for the discharge of the gun and injuries to his colleagues. He began discussing this defense and nurturing this false narrative before he began his interview with law enforcement the same day as the fatal shooting. So, yeah. Ultimately, Mr. Baldwin arrived at the sheriff's department for a formal interview and was left momentarily in the interview room after the video recording of the interview began, but before detectives entered the room to begin speaking to Mr. Baldwin. I did a review of this interview, and I was horrified by what he was doing, because this is crazy town. During this time, Mr. Baldwin, knowing that Ms. Hutchins had been critically injured and taken by a helicopter to a nearby trauma center, and Mr. Souza had been seriously injured and taken to a local hospital for emergency treatment, began to make casual phone and FaceTime video calls. Mr. Baldwin called his wife on speakerphone or FaceTime and another personal assistant / employee regarding his family's upcoming trip to New Mexico. Mr. Baldwin's minor daughter was going to have a small part in the movie, and his family was planning to join him in New Mexico the following day. During these calls, Mr. Baldwin asked that his family not cancel the trip to New Mexico despite the tragedy. He explained, "I won't work and we'll go and enjoy ourselves. It's all paid for. They're not going to give us the money back." Does that not sound like a really callous and cruel thing to say? You've got two people who he's described as his friends. He said these are his friends, and that this is part of why it's such a tragedy for Mr. Baldwin, is that his friends have been injured and killed, and he's worried about the money back. Okay, that's a choice, and that's a choice you made on a recording. Mr. Baldwin proceeded to provide a video-recorded interview with detectives where he described the incident that led to the shooting of Ms. Hutchins and Mr. Souza. They say, in sum, Mr. Baldwin stated numerous times that Hannah Gutierrez handed him the gun before the incident, and Mr. Halls never handed him the gun. Mr. Baldwin stated on 2 occasions that he fired and shot the gun. Mr. Baldwin stated numerous times that he, referring to Mr. Souza, was telling him where to point the gun during the rehearsal, not Ms. Hutchins. Now, note, this is important because later he would claim that Ms. Hutchins tells him where to point the gun, and if he's lying about this, then his credibility is shot. Like, anytime you give interviews, you run the risk that your evidence is going to contradict itself. And he gave multiple interviews where his evidence is contradictory. His story is not straight from one interview to the next. And that is going to be a big problem for Mr. Baldwin at trial, especially if he chooses to testify. But even if he doesn't, they're going to play these. It is also worth noting that Mr. Baldwin stated that Ms. Hutchins turned her body while speaking to someone else, and that is why she was struck in the armpit. Mr. Baldwin never stated during his lengthy interview with law enforcement that Ms. Hutchins told him where to point the gun or gave him any instructions about what to do with the gun during the rehearsal/blocking when the gun discharged. Mr. Baldwin did state during his initial interview with detectives that the gun just went off, as he was not expecting a live round to be in the gun, but he never stated that he didn't pull the trigger. It is true that Mr. Baldwin consented to an extraction of his cellular phone by the Suffolk County Police Department, but only permitted a very limited report to be generated for New Mexico law enforcement to review. The special prosecutors learned recently that Mr. Baldwin has since obtained the extraction data from the Suffolk County Police Department, so it can no longer be accessed by law enforcement. This is important because they were saying he's been so cooperative. He's given a full download of his phone, and they're going, is he that cooperative? He gave very limited permission and then took this out, like took it away. On December 3rd, 2021, after obviously having conferred with counsel, Mr. Baldwin participated in a televised interview with George Stephanopoulos, Mr. Baldwin's personal friend. During this interview, everything changed, and Mr. Baldwin, with the aid of his attorneys, lied with impunity and blamed the incident on Ms. Hutchins. Mr. Baldwin changed his story and stated repeatedly that it was Ms. Hutchins who was telling him where to point the gun and to point the gun at her. And you can see that's not what he said in his police interview. So, were you lying in the George Stephanopoulos interview? Were you lying in the police interview? Which is it? She is cutting him to ribbons in this filing. This is really good. Like, as a defense lawyer, I'm just going to say she's got game. She's got serious game. This is well written. This is well backed up. You can see the citations where she's quoting to specific parts of these interviews that she is putting this together. She's brought the receipts, and she knows how to play those receipts. This is powerful lawyering. I am impressed. And I don't normally say that about a lot of work. You know, I am really impressed by this. In his shameless attempt to escape culpability for his own negligence and recklessness, he went so far as to say that he pointed the gun at Ms. Hutchins' armpit because that was where she told him to point it. And that seems really weird, right? If you're saying, like, here's where you should point the gun, why would you say point here? Who says point at my armpit, right? And who's the only person who could say otherwise about where... Well, she's dead. Oh. So, Yeah, this statement was in direct contradiction to his previous statement on October 21st, 2021, and very pointedly in direct contraction to the portion of his October 21st, 2021 statement where he clearly explained that Ms. Hutchins was struck in the armpit because she was turned to speak to someone else. Very notably, this is the first time that Mr. Baldwin claimed he never pulled the trigger of the gun, thereby calling into question the functionality of the gun. There's going to be more on this as we go. On December 8th, 2021, Mr. Baldwin provided a recorded interview with Lorenzo Montoya of New Mexico, OSHA. If you watched Hannah Gutierrez's trial, you remember Mr. Montoya. I am Lorenzo Montoya. I am here from OSHA. Prepare to be audited. Yeah, that guy. In this interview, Mr. Baldwin's story changed again. And importantly, recorded interview. When speaking to OSHA investigators, Mr. Baldwin told new lies and doubled down on previous lies. Again, Mr. Baldwin stated that he didn't pull the trigger of the gun. In a surprising turn of events, Mr. Baldwin stated that Mr. Halls, the first assistant director, handed him the gun. This was in direct contradiction to the numerous times Mr. Baldwin stated that Hannah Gutierrez handed him the gun when he was interviewed on October 21st, 2021. Mr. Baldwin again stated that Ms. Hutchins was telling him where to point the gun in her direction, and to cock the gun. Mr. Baldwin's new story to OSHA on December 8th, 2021 included new misrepresentations that Seth Kenney was on the set of Rust on October 21st, 2021, and that he heard this from very reliable people. Now, we know from Hannah's trial that he was not on the set. Mr. Baldwin asserted that Seth Kenney was one of the people who may be responsible for providing live rounds to the set of Rust. Defense counsel have never provided the special prosecutors with the names of the very reliable people who told Mr. Baldwin that Seth Kenney was on the set the day of the shooting. So you'd think you would provide that if you had it, right? When Mr. Baldwin planted the seed that Mr. Kenney was on set on October 21st, 2021, and provided live rounds to the movie set on October 2021, the digital evidence proving that the live rounds were on set long before October 21st, 2021, had not yet been uncovered and disclosed. This was yet another falsehood put forth by Mr. Baldwin to deflect blame away from himself and onto others. You saw in the Hannah Gutierrez Reed trial, the level of detailed analysis they put all of those video things through in order to track the live rounds. They hadn't done that work yet. And so that allowed Mr. Baldwin to make these statements that were not true because he didn't know that that was known yet. And I think she's doing a really good job. And I said before that I thought Baldwin was going to walk. She's pushing it a lot further towards Baldwin may not, because why is Baldwin lying about all of this? Why is he telling all these different stories if he didn't think he did something wrong? If Baldwin thought that his actions were righteous, why is he got to keep changing the story? Right? That's going to be something that the jury's going to have to grapple with, is how come he's got so many stories? And if he gets up to testify, he can't be consistent with his prior statements because there's so many inconsistencies. If he gets up to testify, all of this is fodder for cross-examination, and she's going to come in like a wood chipper, and she's going to come and shake his hand, and you don't want to have your hand shaken by a wood chipper. It doesn't end well. As the OSHA interview continued, Mr. Baldwin's story took a very interesting turn. Mr. Baldwin vacillated between claiming he had virtually no experience with guns and almost daily experience with guns. We actually saw that in his police interview, where sometimes he's like, I don't know guns, I just rely on the armor. And sometimes he's like, let me show you how much I know. Mr. Baldwin stated that he pulled the hammer of the gun back, but was not going to cock the gun. This is a stupid statement, because what is pulling the hammer of the gun back other than cocking the gun? It doesn't take much pulling of the hammer back to put it into a quarter cock. It's actually a very tiny little bit of space. So anyone who's ever shot a single action revolver understands that pulling the hammer back is precisely the action that cocks the gun, thus making Mr. Baldwin's assertion contradictory and absurd. Mr. Baldwin also stated that when pulling the hammer back, he did not hear the clicking sounds that the gun makes at quarter cock, half cock, and full cock where the hammer is being cocked. And she is about to drop a rock on him. Just absolutely drop a rock on him. And she is 100% correct about the operation of the guns. I may have to do a video just about this element. Just playing around with the gun up at the mic so that you can hear this. Whether Mr. Baldwin realized it or not at the time of his statement, when the gun handler pulls the hammer back on a single-action Army revolver and doesn't hear the clicks, it means the trigger was fully depressed during the cocking sequence. To an experienced gun handler, Mr. Baldwin's statement that he did not hear the hammer clicks is synonymous with the trigger being pulled. Mr. Baldwin then made the false statement that he did not pull the hammer all the way back. This assertion has already been disproven by forensic testing of the firing pin impressions on the spent casings from the live round that killed Ms. Hutchins. Damn, she's good. Finally, and despite his lawyer's attempts to mislead the state, the court, and the public about the functionality of the guns, Mr. Baldwin made a truthful statement and acknowledged that the gun functioned properly and that the only problem with the gun was that a live round was in it. In sum, every time Mr. Baldwin spoke, a different version of events emerged from his mouth, and his later statements contradict his previous statements and his attorney's assertions as set forth in their motion to dismiss. I.e., are we going to believe the lawyers or are we going to believe the lying client? Because we can't believe both. After Mr. Baldwin's interview with George Stephanopoulos, detectives became aware that Mr. Baldwin was claiming that the gun discharged without the trigger being pulled. Even though this assertion is absurd on its face, law enforcement was dedicated to a full and fair investigation, and in response to Mr. Baldwin's claims, the gun was sent to the FBI for forensic testing. So basically, they say he said he didn't pull the trigger. So we decided to check that out, right? We didn't think it was true, but we decided to check it out just to make sure, because we're trying to make sure that, you know, if it's not his fault, then we'll cut him loose. So the FBI tested the gun and was only able to make the gun fire absent a trigger pull when the hammer was in its full resting position. This is not a malfunction, as Mr. Nikas would like the court to believe. This is predictable and is a known consequence of the gun's design. In fact, the manufacturer's manual for the gun cautions against the handler keeping a round in the cylinder chamber that aligns with the firing pin because significant pressure on the hammer can press the firing pin into the primer of the cartridge and discharge the bullet. So, see Defendant's Exhibit, the Pieta manual. So, the FBI hit the hammer of the gun with a rawhide mallet on numerous occasions when the hammer was in the quarter, half, and full cock positions in an attempt to test Mr. Baldwin's assertion, and ultimately and unsuccessfully tried so hard and so often to make the gun fire absent a pull of the trigger that the gun finally broke. The gun was not destroyed, as Mr. Nikas claimed, but a small number of the internal mechanisms that engage when the gun is in the full cock position were damaged, and one such mechanism was the full cock notch on the gun's hammer and the trigger sear. So, they say shortly after the charges against Mr. Baldwin were filed, his attacks and retaliation against the prosecutors for daring to hold him responsible began. This shouldn't have come to a surprise to undersigned counsel, given Mr. Baldwin's history of attacking anyone who tries to hold him accountable for his bad acts. A more complete recitation of Mr. Baldwin's history of attacks and deflection, with the aid of his counsel, Mr. Nikas, is set forth on pages 16, 17, and 19 of the state's attached Exhibit D. Please see receipts. While there is merit to the defendant's assertion that he was incorrectly charged with a firearm enhancement, and Ms. Reeves' position as a state legislator may have precluded her from serving as a special prosecutor, these were innocent mistakes that were quickly cured by the dismissal of the firearm enhancement and Ms. Reeves' resignation. We solved those problems. You try to make a huge deal out of those. We agree those were problems. We fixed them. They're done. Any allegation that the former prosecutors engaged in an unethical disparagement of Mr. Baldwin by providing limited statements to the press is legally unsound. As has been previously litigated in the case against Hannah Gutierrez during the Baldwin grand jury litigation, the media contact by Ms. Carmack-Altwies and Ms. Reeb was not unethical or unlawful, as it was done in response to Mr. Baldwin's and Mr. Bowles' own public appearances and misleading statements to the press. So, I've lost. Mr. Baldwin made numerous public appearances to spread misinformation about the case, protect his already tarnished public image, and to try to sway the public and future jury in his favor. As discussed above, Mr. Baldwin appeared on national television on December 3rd, 2021, and shamelessly lied about his conduct and blamed the victim for her own death. On August 19th, 2022, and tons of legal commentators said that when he went on that interview, they said this is going to come back and hurt him. This is going to really bite him in the butt. And now we're seeing it. She's got the receipts, and the person who wrote those receipts is Mr. Baldwin. On August 19th, 2022, Mr. Baldwin again used his celebrity status to sway public opinion concerning the details of the investigation into the death of Halyna Hutchins by appearing on CNN for an in-person interview with Chloe Melas. On August 19th, 2022, Mr. Nikas appeared in an interview with Chloe Melas prior to any charging decisions against his client being announced by the district attorney's office. Mr. Nikas stated that any criminal charges against his client would be a huge miscarriage of justice. A prosecutor is not required to stay silent under these circumstances. She is permitted to rebut the parade of misinformation spread about by Mr. Baldwin, his counsel, and counsel for Ms. Gutierrez. The New Mexico Rules of Professional Conduct on trial publicity states a lawyer shall not make any extrajudicial or out-of-forum statement in a proceeding that may be tried to a jury that the lawyer knows or reasonably should know, 1, is false, 2, creates a clear and present danger of prejudicing the proceedings. The committee commentary goes on to state in footnote 6, and this is the key thing, finally, extrajudicial statements that might otherwise raise a question under this rule may be permissible when they're made in response to statements made publicly by another party, another party's lawyer, or third persons where a reasonable lawyer would believe that a public response is required in order to avoid prejudice to the lawyer's client, in this case, the state. When prejudicial statements have been publicly made by others, responsive statements may have the salutary effect of lessening any resulting adverse impact on the adjudicative proceeding. Such responsive statements should be limited to contain only such information as is necessary to mitigate undue prejudice created by the statements made by others. So basically, she is saying, yeah, we made some statements because you did first, and we get to reply. And you wouldn't stop making statements. You wouldn't stop appearing on interviews and news and so forth. So you open the door, we get to walk through it. It is perplexing that Mr. Baldwin would complain about pretrial publicity when it was he who elected to appear on national news and use his celebrity status to publicly lie about the facts and circumstances of Ms. Hutchins' death. The prosecution is permitted to respond to statements made by the defendant and/or his or her counsel to lessen the adverse impact on the adjudicatory proceedings. So they say that they reached out to Mr. Nikas and Mr. Spiro to establish a civil working relationship. After some brief introductory meetings, Mr. Nikas requested the defense counsel and counsel for the state meet in person to fully discuss the case against Mr. Baldwin, and undersigned counsel graciously and naively agreed. She said, I was a sucker to think you would be treating me fairly. So April 12th, they flew to Santa Fe and met with the special prosecutors to discuss the case. During this 4-hour meeting, Mr. Nikas displayed a PowerPoint presentation that outlined his arguments against the prosecution of his client. During this meeting, Mr. Nikas stated that if the case proceeded, he may call a variety of A-list actors to testify on Mr. Baldwin's behalf, and specifically referenced Harrison Ford and Helen Mirren. both of whom are awesome. Mr. Nikas went further and stated that if the case were to proceed, he would call Mr. Baldwin's supporting actor on Rust, Jensen Ackles, as a witness for the defense. Also awesome. Also awesome. I would love to talk to Mr. Ackles one day, and it will probably never happen, but yes. All right. Mr. Nikas explained that Mr. Ackles would testify that even though he personally checked his prop gun for live rounds routinely, as he testified to in his interview, he would not have checked if he had been in the same position as Mr. Baldwin on October 21st, 2021. Mr. Nikas also asserted that Mr. Baldwin's position as producer on the film gave him power over creative decisions only, and that his contract spelled out those limitations clearly. Nearly all of Mr. Nikas' statements to counsel during the meeting on April 12, 2023, would later be determined to be false or misleading. Oh, like, hey, we gave you all the chance to explain and you came in and you lied to us. That's a hell of an allegation, right? So, oof. The deadline for the defendant to list witnesses under Rule 5502 was March 1st, 2024. So they had a time limit for when they had to say who they were calling. And not surprisingly, he has failed to list Mr. Ford, Ms. Mirren, or Mr. Ackles. They said they'd be calling these people, that they would be providing ironclad evidence to help Mr. Baldwin. They're not calling them. In fact, undersigned counsel recently contacted Mr. Ackles and was notified that no one from Mr. Baldwin's defense team has ever reached out to him and requested he testify on Mr. Baldwin's behalf. They didn't even call Mr. Ackles. Didn't even get on the phone. They told the prosecutor that he was ready to testify, and apparently they never talked to him. This is a big allegation. The prosecutor is straight up calling the other side a liar. Whew, gloves are off. Mr. Nikas intentionally made numerous false statements in his motion to dismiss, but one of the most shocking is his assertion that the defense proved to the state that the gun used by Mr. Baldwin was modified. On April 18, 2023, Mr. Nikas emailed undersigned counsel 3 photos of revolver parts. One photo was from the FBI examination of the gun used to kill Ms. Hutchins, and the other 2 presumably came from the defense firearms expert, Brian Lutke, who has yet to be listed as a witness for the defendant, despite the fact that he examined the evidence revolver at the Santa Fe County Sheriff's Department on April 12, 2023, and is scheduled to examine it again in the coming weeks. So you got your expert. Why is your expert not testifying? I'm guessing he's got some bad things to say. I'm guessing he's got some things that are harmful. That's why. So, yeah. Mr. Nikas used these photos to convince undersigned counsel that the hammer of the revolver may have been modified because it appeared to be visibly different than similar exemplar hammers. Undersigned counsel had already retained the services of Lucien Hogg, who was to be assisted by his son Michael Hogg to perform forensic testing on the revolver, and intended to defer to their examination and testing with regard to the oddity of the hammer. We saw Lucien Haig testify at the Hannah Gutierrez Reed trial. He was very good as an expert. The Haigs are recognized nationally and internationally for their expertise as forensic scientists in the areas of ballistics generally, shooting reconstruction, and firearms examination. At the time, the preliminary hearing for Mr. Baldwin was scheduled to begin on May 3rd, 2023. The special prosecutors could easily have proceeded successfully to a preliminary hearing on Mr. Baldwin's case, even though the forensic testing of the gun was incomplete. The simple fact that Mr. Baldwin did not have personal knowledge of the ammunition loaded into the gun, pointed the gun at a person, and admitted to detectives that he fired it was likely to be enough to surpass the probable cause standard. We had enough to charge you. Because remember, Baldwin's defense counsel makes a big deal about how they withdrew the charges for a substantial period. However, Mr. Nikas contacted undersigned counsel and specifically requested she consider dismissing the case against Mr. Baldwin without prejudice while the forensic testing took place to ensure that Mr. Baldwin did not have to bear the expense of paying his numerous elite attorneys to defend him at the preliminary hearing, only to later have the case dismissed if the forensic testing indicated that the hammer of the gun had in fact been modified. Undersigned counsel agreed to dismiss the case without prejudice pending the outcome of the forensic testing and the resolution of outstanding discovery issues related to Mr. Baldwin's producer contract and other items in the possession of Rust Productions, LLC. We did you a favor. You asked us to do you a favor, and now you're trying to use that against us? You absolute snakes in the grass is what Morrissey is saying here. Mr. Nikas asserted in his motion to dismiss that Mr. Baldwin is somehow shocked and surprised by the refiling of the charges against him. This is patently false, given that the agreement entered into between Mr. Nikas and undersigned counsel was that the case would be dismissed without prejudice pending the outcome of the forensic testing of the firearm, and the null prosequi filed in the case specifically stated that the investigation was ongoing. So again, she's going, you liar. You liar. Predictably, the forensic testing concluded that the trigger of the gun had to be pulled for the gun to have discharged on October 21st, 2021, and the alleged modification of the hammer was simply damage caused when the FBI struck the hammer with the mallet so many times that it finally damaged the hammer and sear. It is worth noting that the damage to the hammer that Mr. Nikas so desperately wants to convince the court was some mysterious modification is damage specifically to the full cock notch of the hammer, and the gun was in the full cock position when the final strike from the FBI's mallet broke the hammer and sear. This isn't rocket science. It's the simplest and most plausible explanation. She's dropping some shade. It is worth noting that further testing of the gun in August 2023 revealed that even when the damaged hammer was inserted back into the gun and the trigger was replaced, the gun would not remain in the full cock position, and the trigger still had to be pulled to drop the hammer after it was caught at the half cock and quarter cock positions. The defendant simply doesn't have a leg to stand on concerning his claim that the hammer of the gun was modified. He used this false claim to create delay in the prosecution of his case and has now complained in his motion to dismiss that the case has been hanging over his head for too long. You lied to us, you delayed the case, and that's why it's taking so long, because we believed your bullshit, and now we've checked it and we found it's bullshit, and we're not buying it anymore. And we're telling you that the court, we're telling the court on you. After receiving the forensic analysis from Mr. Haig, undersigned counsel was finally able to obtain the video recordings from the filming of Rust, which also clearly demonstrated that the gun was in perfect working condition every time it was fired by Mr. Baldwin. The videos also confirmed the witnesses' statements regarding Mr. Baldwin's bullyish behavior on set, and that Mr. Baldwin's producer contract was completely devoid of the limitations promised by Mr. Nikas in the April 12th, 2023 meeting. So, yeah. It was now October 2023, and the case was finally ready to be refiled. As disclosed in Defendant's Exhibit 4 to his motion to dismiss, and previously to NBC News, counsel for the state gave Mr. Baldwin the option of accepting a very favorable plea agreement rather than having the case proceed to grand jury for a possible indictment. Counsel extended this plea offer reluctantly, but did so with the intention of ensuring that similarly situated defendants do not receive disparate treatment, i.e., she offered the same deal to Baldwin that she offered to Hannah, a deal that would have kept them out of jail. Mr. Halls was offered a favorable plea deal, and it seemed only fair to extend a similar offer to Mr. Baldwin prior to proceeding to a grand jury presentation. Prosecutors are certainly not bound by the philosophical notion that all similarly situated criminal defendants must be treated similarly, but undersigned counsel is not a career prosecutor. Rather, she's a career defense attorney and civil rights lawyer, and believes strongly in issues related to fundamental fairness. This is where what Morrissey is saying here is, sir, fuck you. That's what she's saying. You are impugning my concern for fundamental fairness and the rights of accused? What do you think I do? What do you think I do for a living? She's not happy. And she's right to be unhappy. Undersigned counsel has learned some tough lessons about the consequences of her idealistic notions during her dealings with Baldwin's counsel, and the series of events that unfolded as a result of the plea offer have been the toughest lessons learned to date. I expected you to behave with honor. You have not behaved honorably. You have been, she's saying you got, so on October 5th, 2023, the special prosecutors extended a plea offer to Mr. Baldwin as confidential and privileged plea negotiations and gave Mr. Baldwin until October 27th, 2023 to accept the offer, or the case would proceed to grand jury on November 16th, 2023. Counsel for the state received no response at all, not even an email from defense counsel stating that they received the offer and would discuss it with their client. Approximately 10 days after the offer was extended and well before the deadline for Mr. Baldwin to accept the offer, undersigned counsel received information that Mr. Nikas provided all of the details of the presumed confidential and privileged plea offer to a reporter with NBC News in New York. So, guys, we'll talk a little bit here about something called resolution privilege or settlement privilege. There is privilege which prevents the disclosure of communications that are for the purpose of settlement, including criminal resolution. This offer that she was extending to say, here's a plea deal, he's not allowed to share it. Like, that's supposed to be secret as between the two of them in order to maintain confidence in that system of plea bargaining. But instead, that goes off to an NBC News reporter in New York. So,
this stuff's made in New York City. New York City!
I mean, yeah. After determining that the reporter did indeed have all the details of the plea offer extended to Mr. Baldwin, undersigned counsel received additional information that Mr. Baldwin and his counsel were working with the media to generate a campaign designed to deflect attention away from any future plea hearing to protect Mr. Baldwin's public image. Counsel received information that Mr. Baldwin may accept the plea offer, but intended to file a civil complaint against the state of New Mexico and the former prosecutors on the same day as the possible future plea hearing to direct media attention to the frivolous lawsuit and away from the plea hearing. So what she's saying is, you guys have been absolutely and completely untrustworthy in a way that, like, she's making allegations that are just absolutely horrible. As disturbing this information was, she's missed a word there, but she's got some typos and so forth throughout. Undersigned counsel was not inclined to rescind the plea offer simply because Mr. Baldwin intended to continue to use the media to escape the consequences of his actions, and his counsel had flagrantly disregarded the privileged and confidential nature of plea negotiations. She says, even though they're behaving absolutely horrible, in a horrible way, I continued to behave honorably. That's what she's saying here. And I can tell you, if I did this on a trial here where I am, I would absolutely expect them to not only rescind any offers, but also to come after me. Like, yeah. All right. Next, undersigned counsel received information that Mr. Baldwin commissioned his own documentary about the death of the woman he killed and was actively pressuring material witnesses in the case against him to submit to interviews for his documentary. Holy shit. It was at this point that the plea offer was rescinded and the case was scheduled for grand jury. And still, Mr. Baldwin complains to this court that he's been treated unfairly. The audacity of doing a documentary about a woman you killed to try to, that is gross. It is worth noting that after the plea offer was rescinded, the NBC News reporter again contacted the undersigned counsel and warned her that she, the reporter, spoke to Mr. Nikas about the retraction of the plea, and Mr. Nikas exclaimed that he was going to destroy undersigned counsel. Undersigned counsel responded that she expected nothing less, i.e., her expectations at this point are way in the dirt. She thinks this guy is absolute crap. In response to Mr. Baldwin's assertions that state's counsel engaged in inappropriate contact with the media and somehow disadvantaged him by removing the language related to the 48-hour deadline from his target notice, undersigned counsel incorporates herein all arguments set forth in state's attached Exhibits E. State's counsel further asserts that had she not removed the language related to the 48-hour deadline from the target notice and then proceeded to request a modification of the deadline, as she did, the defendant would have complained that he was being mistreated by being provided a 48-hour deadline and then having the state motion the court to modify the deadline. So at this point, where she's basically making this hypothetical of you would still complain had I done it the other way, she's hoping that the court is already in agreement that Baldwin's counsel is behaving badly. Because if the court isn't there yet at this point, the court isn't going to accept this hypothetical. But if the court is with her, then the court will go, yep, that makes sense. Mr. Baldwin wasn't disadvantaged. He wasn't treated unfairly, and the state never requested that his time to respond be shortened to anything less than what the rule contemplated. The reasons for requesting a modification of the deadline were to ensure that the court would have ample time to address the legal issues raised by the defendant's anticipated alert letter, and that the state could timely accommodate the travel arrangements for the out-of-state witnesses scheduled to appear before the grand jury without disruption. In the end, state's counsel was right. There was not ample time for the court to address the defendant's arguments, and the court vacated the grand jury presentation scheduled for November 16th, thus demonstrating that the state's request for a scheduling order was not at all frivolous. And this is going to be, I said I stopped highlighting because it's just everything, but I highlighted this because it needs some emphasis. In his motion to dismiss, Mr. Baldwin complained about counsel's contact with an NBC reporter on November 15th, 2023. In truth, the sole reason undersigned counsel had any contact with the reporter is because Mr. Baldwin's counsel released to NBC News all videos from the filming of Rust that they requested be provided to the grand jury as exhibits in their grand jury alert letter. Defense counsel released the videos to NBC the night before the grand jury was scheduled to convene and modified the videos to show their client in a more favorable light. The night before the grand jury was scheduled to convene, they are releasing to a news organization modified videos? Oh! I mean, if she can back up these allegations, she's coming for people's careers. She's not playing. She is not playing at all. Undersigned counsel did not provide the January 2023 grand jury date to anyone other than the witnesses being called before the grand jury and instructed those witnesses not to disclose it to anyone else. So we weren't the leak, you were the leak. Undersigned counsel did not yell at the reporter from NBC News, nor did she threaten her with a subpoena. Undersigned counsel explained her contact with the NBC News reporter in detail during the grand jury litigation and has attached those pleadings for the court's review and consideration. Undersigned counsel incorporates all statements and arguments in this regard made during the grand jury litigation, including in Exhibit E. The meat of Mr. Nikas's arguments related to the presentation of the charges to the grand jury demonstrate a fundamental ignorance on the part of Mr. Nikas with regards to the law as it relates to grand jury proceedings in the state of New Mexico. Why? Because he's from New York City. First, the presenting prosecutor is not required to notify the grand jurors of their ability to subpoena witnesses or documents. This is the purview of the court. The grand jurors don't walk off the street and sit down in the grand jury room with no information about their powers. The grand jurors go through a formal orientation where they are verbally notified of their ability to subpoena witnesses and evidence, and they're provided with a written packet that instructs them on their powers. See Exhibit F. We're attaching the packet. There's the receipt for that. The written instructions provided to the grand jury by the court clearly state the presiding judge of the grand jury will guide you to assure that your actions are within the authority conferred upon you by law. Any grand juror may at any time, with propriety, seek advice and guidance from him or her as to the scope and propriety of the grand jury's acts and investigations. The grand jury has the power to order the attendance of witnesses and to cause the production of public and private records or other evidence relative and relevant to its investigations. It has the authority of this court to subpoena witnesses and to obtain execution of subpoenas. Mr. Nikas is correct. The court ultimately ordered the state to make nearly all of the defendant's requested evidence and witnesses available to the grand jury by way of an alert letter, and the state did exactly as instructed, and Mr. Baldwin was subsequently indicted. The state went beyond what is required of prosecutors presenting alert letters to the grand jury. Not only did the state read every word of Mr. Baldwin's alert letter to the grand jury, but the state also provided each and every grand juror with their own copy of Mr. Baldwin's alert letter. Even though the alert letter provided to every grand juror detailed the documents Mr. Baldwin requested the grand jury consider, the state had copies of each and every document for each grand juror in the room. There were 3 banker's boxes of documents sitting in the room, and at the conclusion of the evidence, undersigned counsel notified the grand jury that copies of all of Mr. Baldwin's requested documents were available for their review should they wish to see them. They're over there in the box. You can go check them out. Now, I don't know if the grand jury is going to be super inclined to check out the box, but she's not required to make the defense case. She's just required to say, hey, it's there for you. The truth is that the grand jurors were alerted to Mr. Baldwin's witnesses and documents, and they had no interest in reading the documents or requesting the attendance of the witnesses. This is typical of grand jury proceedings where the target does not testify, as is his right. Baldwin, if you're not testifying, they're not interested in all of these other witnesses that you say you have because they already understand. The state provided Mr. Baldwin's requested proximate cause instructions, read the instructions to the grand jury verbatim, and included the instructions in the packet of instructions that the grand jurors were required to consider. Mr. Baldwin complained in his motion that the state didn't take enough time to present the case to the grand jury and rushed through the presentation. This assertion is absolutely false and another attempt by Mr. Baldwin to receive special treatment. The state spent 1.5 days presenting this case to the grand jury. This is an unprecedented amount of time to spend presenting any case to a grand jury, let alone a 4th-degree felony. The Baldwin grand jury presentation was likely one of the longest in New Mexico history and almost certainly one of the longest in the history of the 1st Judicial District Court. The grand jury presentation was unusually long because there was a great deal of evidence, witnesses, and exculpatory material that needed to be presented. Upon reading the laughable presentation, or laughable assertion that 1.5 days was not long enough, undersigned counsel gathered information from prosecutors in the 2nd Judicial District, which is considerably greater in population and crime rates than the 1st Judicial District. So she went and asked around. She spoke to 2 prosecutors who routinely indict and prosecute capital murders, child abuse resulting in death, child molestation cases, and adult rape cases, and both prosecutors reported that the longest grand jury presentation they have ever participated in lasted no longer than 3 hours, which is a lot shorter than 1.5 days, right? Mr. Nikas complained in his motion that the prosecution rushed through the grand jury process and should have postponed the grand jury presentation, and simultaneously complained that the charges have been hanging over Mr. Baldwin's head for far too long. Pick a lane. There's simply no pleasing Mr. Baldwin or his counsel. As proof, Judge Ellington granted nearly all of Mr. Baldwin's pre-grand jury requests, and after the indictment was filed, the criminal case was assigned to Judge Ellington for trial court proceedings. So he gave them basically everything that they wanted, and then was assigned to the trial. What's his response? By excusing the judge who granted nearly all of his pre-grand jury requests. They kicked him off the trial. They kicked him out of the file. Why would the defense excuse a judge who seemingly bent over backwards to accommodate his countless requests? probably because Judge Ellington denied his request for a modification of the uniform jury instruction that was absolutely contrary to New Mexico law and failed to act on his frivolous motion for sanctions against the special prosecutors. So you got almost everything you wanted, but he didn't give you everything. And so, like a spoiled baby, you lash out. A cursory review of the allegations contained in his motion to dismiss demonstrates that Mr. Nikas misled the court at nearly every turn in his publicly filed pleadings. An allegation of misleading the court is actually a pretty big deal, right? You can get punished for that. So, on page 21 of his motion, he stated, Haig omitted several essential facts regarding that testing, referring to the forensic testing of the gun, including that the FBI testing established that the gun did fire without a trigger pull when the firearm was fully loaded with 6 rounds, as it was on the day of the incident. False. On the day of the incident, the gun was fired from the full cock position. During FBI testing, the gun only fired without a trigger pull when the hammer was in the resting position, as it is designed to do if a cartridge is loaded into the chamber of the cylinder that aligns with the firing pin. Also on page 21, Haig admitted that the hammer of the firearm that fired the fatal round was rounded, which would make it easier to fire. False. There's simply no evidence that the hammer was in anything other than perfect condition at the time the gun fired the fatal round into Ms. Hutchins' body. And if Mr. Nikas doesn't believe Mr. Haig or the counsel for the state, then perhaps he's willing to believe his own client, who told OSHA investigators that there was nothing wrong with the gun. The only problem was that it had a live round in it. Whoops. Making statements causes you problems. On page 25, Mr. Nikas argued that Mr. Carpenter told the grand jury that the safety bulletins issued by the Screen Actors Guild placed responsibility for firearm safety on the actor, and asserted that this statement is false when in fact the statement is true. And they point to the Screen Actors Guild Section 11 and other weapons. I'm going to note the state here has a copy of the Screen Actors Guild documents from before this. The Screen Actors Guild later started saying, whoa, it's not the actor's fault. But they said some different things in their documents before this. Treat all weapons as though they are loaded and / or ready to use. Never point one at anyone, including yourself. The same language is found in SAG Safety Bullet number 1, firearms, along with the following statement. Never place your finger on the trigger until you're ready to shoot. Keep your finger alongside the firearm until you're ready to shoot. Know where and what your intended target is. These are the rules for actors handling firearms on movie sets, and Mr. Baldwin managed to disregard every single one of them. Mr. Nikas is incredibly articulate and very persuasive, but he certainly is not devoted to truth-telling. Damn. Mr. Nikas also demonstrated his ignorance of the rules of evidence as they pertain to grand jury proceedings and criticized the state for presenting its investigator, Connor Rice, to testify as to hearsay related to the investigation and the incident. Hearsay is permitted in grand jury proceedings, and during most grand jury proceedings, the state only calls one witness who testifies largely to hearsay learned from other sources. So that's how we do it. Mr. Nikas accused the state of redirecting the grand jury's inquiries to the witnesses in an attempt to disadvantage Mr. Baldwin, when in fact the state deferred the grand jurors' questions on a couple of occasions because the grand jurors were asking questions of witnesses who were not qualified to answer them. The state purposefully called witnesses back to the stand after their testimony was complete so that the grand jury could have their questions answered completely and by the most qualified witnesses. For example, on page 30 of his motion to dismiss, Mr. Nikas pointed out that when a grand juror asked Detective Hancock a detailed question about the protocols for gun safety on movie sets, the state asked the expert movie set armorer to address the question rather than the law enforcement officer who has never worked a day on a film set. Now, correction, I think she's worked one day on a film set, but it wasn't a good day. This conduct was appropriate and designed to ensure that the grand jury received the most reliable information available to them. Mr. Nikas argued that the grand jury never heard from Joel Souza, Ryan Smith, Dave Halls, or Sarah Zachary as a result of undersigned counsel's diversions. In fact, the grand jury did not hear from these witnesses because they chose not to order the state to produce them after being alerted to every word of Baldwin's alert letter and being fully aware of their powers to compel witness testimony. It is worth noting that only one of these witnesses has been disclosed by the defendants in accordance with New Mexico rules, i.e., they said, why didn't you hear from Joel Souza, Ryan Smith, Dave Halls, or Sarah Zachary? And they're only calling one of those people as a witness. So even at trial, they don't think that those people are going to be, or 3 out of 4 are going to be useful to them. So for all of Mr. Nikas's complaints about the way the grand jury presentation was handled, he failed to remark on the fact that the state spent a large amount of time during the presentation demonstrating that Ms. Gutierrez was the source of the live rounds found on the set of Rust. Ms. Gutierrez was the person who loaded the live round into the gun, and Mr. Baldwin had no reason to believe there was a live round in the gun, given that he opted to forego the industry standard safety protocols available to him, and did so at his own risk and the risk of those to those around him. Mr. Baldwin's failure to exercise his option to simply observe the armorer load the dummy rounds into the gun and visually and / audibly determine to the actor that the rounds are safe, inert dummy rounds was not a violation of the SAG safety bulletins, but it was a violation of New Mexico law. And here's the thing. Screen Actors Guild doesn't get to make the law. They get to make policies for movie sets, but that's not the law. New Mexico law prohibits the negligent use of firearms, and this is actually contemplated in the SAG safety bulletins. On at least 4 separate occasions, the SAG guidelines and safety bulletins state these guidelines are recommended by the industry-wide Labor Management Safety Committee and should not be considered binding laws or regulations. However, state, federal, and / local regulations applies and would override the guidelines. And where would this be significant? Well, I'm a Canadian lawyer. I can tell you Canadian law is pretty strict about this kind of thing. And so if you're filming a movie in Canada, you better follow those laws. Full stop. Mr. Nikas complained on page 35, paragraph C of his motion, that the special prosecutors issued an improper and prejudicial instruction to the grand jury. This is patently false. The prosecutors did not deviate from the uniform jury instructions. We simply filled in the language that was required to be filled in, and we did so in accordance with the instruction and the facts presented to the grand jury. Mr. Nikas would like the instruction provided to the grand jury to read, 1, the target discharged a firearm during the production of the movie. 2, the target should have known the danger involved from the target's actions, etc., etc. This argument is ridiculous. The reason Baldwin's behavior was a violation of the law is because he pointed a gun at a person, cocked it, and pulled a trigger having no personal knowledge of what type of ammunition was in the gun. This is a violation of basic gun safety and New Mexico law. There is a fundamental difference between a gun handler not having personal knowledge of the ammunition in the gun and pointing it at a person, cocking it, and pulling the trigger, and having subjective knowledge that there's a live round in the gun, pointing it at a person, cocking it, and pulling the trigger. The difference is that the first satisfies the elements of involuntary manslaughter, a 4th-degree felony, and the second is second-degree murder and / or depraved mind murder, a 1st-degree felony. So the argument she's making here is that the instructions that were requested by the defense were that the jury be told basically the criteria for second-degree murder. And she says, we're not actually saying that you committed second-degree murder. We're not saying that at all. We are saying that you committed involuntary manslaughter. That's why you're looking at a max of, not much time versus jail for the rest of your days. So Mr. Baldwin had a duty to confirm that only inert ammunition had been placed in the gun before pointing it at a person, cocking it, and pulling the trigger as a gun handler in the state of New Mexico, subject to New Mexico laws, and its failure to do so resulted in negligent homicide as long as the other elements of the crime are satisfied. Judge Ellington's January order, provided as Defendant's Exhibit 11, contradicts Baldwin's assertions and arguments to this court. So paragraph 11 required the state to alert the grand jury to the existence of the following witnesses and their potential testimony via the target's grand jury evidence alert letter. All they're required to do is provide the alert letter. So, yeah. This was done verbally and in writing to every grand juror in the room. We followed the order. We're good. In paragraph 11b1, Judge Ellington ordered the state to alert the grand jury to the existence of documents 1 to 8, 10, and 12 to 14 via the target's grand jury evidence alert letter. So, in paragraph 11c1, the state was ordered to actually present documents 9 and 11, and we did so. The grand jury did not elect to hear from Baldwin's witnesses, and if they had elected to hear from them, they would have been presented in person, virtually after seeking and obtaining approval from the court, or via video recorded statements they previously provided to law enforcement and pretrial interviews. The grand jury did not elect to hear from Mr. Baldwin's witnesses, and therefore no scheduling disruptions were encountered. We would have done it. They just didn't want it. We don't have to show them the witnesses. We only have to tell them that they can talk to the witnesses. So in paragraph 16 of his order, Judge Ellington's noted or cited to State versus Herrera. Once alerted to target offered evidence, the grand jury remains free to decide not to hear the evidence or to hear the evidence and weigh it as it sees fit. The state followed Judge Ellington's order to the letter, and Mr. Baldwin was indicted. So, we respectfully request that this court deny Mr. Baldwin's motion to dismiss by Carrie T. Morrissey. And they got a lot of exhibits. They got, like, this is 316 pages. So there's like 300 more pages of stuff. That includes transcripts of his police interview, of the George Stephanopoulos interview, of his other interviews, so this is the OSHA interview. I can do videos going through all of this stuff later. They've got all of this stuff in here. And so there's a lot of fire in this. And I gotta say, there were places in the defense motion to dismiss that I was like, they might have a point here. They might have a serious point here. All of those places she addressed very adeptly. Very adeptly. And there were places where I was like, it seems like they might be full of crap here. And she came in and she addressed those too. She was hammering those points. And not only that, but she throws a lot of shade. She throws a lot of criticism and a lot of allegations. And every time she's like, hey, are you sure? She backs it up with receipts. This is going to be interesting, but at this point, I didn't think they had a great shot at their motion to dismiss because it's always hard to throw at a case when you've got a death on the line. I think that she's killed that. I don't think that they're going to get their motion to dismiss. So
that concludes the motion to dismiss. One thing we can take from this is that the hearing, when they eventually have it, is going to be spicy. There's going to be a lot of fireworks because there's a lot of allegations being thrown back and forth. And both sides have made allegations essentially of misconduct to the other side. The court's going to have to sort that out. I think the court is probably going to tiptoe around those particular allegations and issues. But there's a lot here to sort out and a lot of different implications and suggestions and so forth. I don't think that they're going to throw the case out. I don't think that's going to happen based on this motion to dismiss and the response. Could be wrong, but that's where I'm landing. So we'll see what happens. Anyway, thank you guys for watching. I hope you found this to be interesting or educational. I also want to thank my Patreon supporters. At the $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association, Purple Dragon Air, and PJs Forever. At the $20 level, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunkle of the Baileys, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.